question, and hopefully you've asked them to speak for 5 minutes, so at the end we will have some engagement with you as the audience, and hopefully we can entertain some question and answers as well. So let me first introduce the first speaker, Professor Herta Däubler-Gmelin. She's a former German Ministry of Justice, and her career spans in many fields like academia, law, and policy making. Professor Däubler-Gmelin has a long history in Parliament and international committees, advocating human rights and gender equality. Her relationships to Uzbekistan go back to the early 90s. I think she mentioned this is, I think, 11th time here. She's a visiting scholar at renowned universities and continues to practice law, including in the area of dispute settlement through mediation and arbitration. Ms. Däubler-Gmelin is also currently a member of the advisory board of Global Neighbors, which is an international think tank, which mission include to inform, connect, and empower business and build bridges between Europe and Central Asia. So, Professor Däubler-Gmelin, my question to you, you bring a lot of international experience to our discussion, as well as a good understanding of Uzbekistan. Can you tell us how you believe that the ICC can support development of the local judiciary in Uzbekistan, and what is the importance of international cooperation when it comes to developing standards? Please.
Thank you, Madam Chair, for this really friendly and lovely introduction. Before answering your question, I would like to thank the organizers of this forum for inviting me. Well, a German lawyer, European lawyer, a bit experienced in international commercial dispute resolving, and a board member of the Global Neighbors, which is an NGO that cares for improve the relations between Europe and Asian countries, especially, let's say, all the countries from China, Uzbekistan, a country which I love very much. And let me add, every time I'm coming back to Uzbekistan, and I admire the old tradition and culture of this wonderful country, I am astonished about the economic development. And of course, I know that you have a really hard-working population, so I think it's no wonder that Uzbekistan is developing so well. But in this panel, we are discussing the Tashkent International Commercial Court, its role and importance, and you are quite right. This court is an interesting court because it's designed to successfully apply modern international standards and to incorporate modern dispute resolution techniques. I think this is one very important thing, because in doing this, this course will be able to create a credible and effective forum for resolving cross-border commercial disputes. We have just read that its core principles are designed to foster confidence among international and domestic parties by providing a transparent and impartial and predictable dispute resolution environment. And this is most important for the international investors' economy, and of course it's good for Uzbekistan as well, as this court could improve the confidence in the national Uzbek judicial system that, alas, we have to state this, because Germany and Uzbekistan are cooperating in improving the judicial system, that in the last years this confidence seems to have declined after a hopeful beginning and development in the years before. We know quite well that a fair and efficient cross-border dispute resolution system is crucial for international trade. This, the President of the Republic of Uzbekistan has pointed out in the forum of 2023, announcing that the Tashkent International Commercial Court will be underway together with an efficient mechanism of, let's say, international enforcement system. This is a most important project, and we all know that not only in Europe, but in the Arab region and in Asia, there are multiple national and regional international commercial courts. The EU has not succeeded in creating a fully developed international commercial court, but many European member states have created their own national courts. Even Germany has a good, efficient one. It took quite a long time, so we know how important but difficult the building up of an effective international commercial court can be. Well, in this congregation of international commercial courts, the Tashkent court has now its place. And of course, we all know that all those courts, to be effective, have to follow, well, strict rule of law standards. And again, I'd like to mention, in this way and doing this, the Tashkent court could be a model for the spirit and the attitude of the Uzbek national courts. I think you have mentioned that in 24, Mr. Rustam-Bekov, when you announced, let's say, the partnership between the TICC and local courts in your wonderful country. But I think we should mention and underline this. Of course, the commercial courts have to follow not only national rules. This is very important. They have to follow and apply rule of law, complying special procedural rules, providing access to international companies by using modern rules and best international practices in compliance with international standards. And I only want to refer to UNCITRAL and the International Chamber of Commerce standards. And of course, we all know quite well that the trend is going to harmonize the international rules. This could be an interesting topic for the Tashkent court as well. I think I don't have to refer to all of the essentials of such an international commercial court. But let me mention only international experts as justices, impartiality, independence, thus creating confidence, transparency, flexibility, managing the case in good time, cost efficiency, and confidentiality are among those essentials, and English language, international enforcement as well. Ladies and gentlemen, there are, as I mentioned before, interesting ICCs in Asia, Astana, Singapore, Hong Kong, India, and Malaysia. These courts are not really competing, but of course they could be partners and they could be rivals for international investors. So I think the Tashkent court will have an interesting task to fulfill. And equally, it will be part of this network. And it could add to the harmonization of the rules of international commercial trust over dispute resolutions and international best practices. Let me come to my conclusion. Not only having an efficient, impartial international commercial court will be an advantage for the national justice system in Uzbekistan and every country, but as well, and most important, advantage of location for international investors. Thank you so much. Thank you.
Thank you very much. Thank you. Thank you for these very valuable comments. I really like the point also you make about the competition and the fact that there are all these international commercial courts elsewhere, and that this court will provide another option. And as we know, I think the court in Astana takes on cases by Uzbek parties. So there is definitely competition. I think it's therefore very valuable for investors here to have this option available locally rather than having to go to another court outside the country. So I'd like to move on to my next speaker. Dr. Nasser Al-Adbar is a professor of international investment law at Qatar University. He also serves as the chair of the Chartered Institute of Arbitrators at the Qatar branch and is an expert member of the dispute settlement body at the World Trade Organization in Geneva. In addition, he is a legal advisor to the World Bank at the International Center for Settlement of Investment Dispute. Dr. Al-Adba is a legal practitioner. His practice encompasses commercial and corporate law in general, along with extensive experience in dispute resolution. So the question I have, you have a lot of experience with the international commercial courts in the Middle East, like we just referred to. And as the TICC is modeled around these courts, can you tell us how these courts have supported increased international investment in the Middle East? So why establishing a dedicated international court rather than depend solely on the national court or international arbitration?
Thank you very much, Marianne, and thanks also for my colleagues and distinguished panelists. And special thanks for my friend Professor Islam Bek for this invitation. Now we have to go back in history. Why establish the international courts either in Dubai, which is Dubai International Financial Courts, and that was almost 20 years back. That was 2004 or 2005. And then subsequently, the QIC-DRC, the Qatar International Court, started at 2010. The idea is getting an customized commercial courts inland to work closely with the foreign investments. And the question why is because the policy makers in those states, they do believe that putting one court with 9 judges from international backgrounds is very beneficial for attracting the foreign investments to the country. That was a fantastic idea. We have good statistics about the foreign investors to come to Middle East and to invest freely in those free zones, and to get the resort finally, if there is any disputes happening, to those international courts. In Qatar, the head of court is a famous English judge called Lord Justice Wolfe, who's been presiding the Commercial Majesty Court in England. And then he served for almost 10 years. He has done a fantastic job. What is the uniqueness about the international commercial courts? First of all, they have their autonomous board, which is not linked to the governments. And that means there is no direct influence about the appointment, about the judges, how much the bonuses, how much the salaries. Governments has no hand on that. It's only the board who has the autonomous to choose the judges and to get any influence from the government elevated. Number 2 is they allow to the foreign lawyers to appear in front of the court. And most of the civil law countries, they don't allow foreign lawyers to engage with local cases inland. And that also gives some exposures to the judges to see a very good lawyers, international reputable lawyers, to appear in front of normal courts. They can make a cross-examinations. They can make an oral statements, disclosure of the document production. All of this never been done in civil law countries. It's all local lawyers, and the local lawyers is local works, the submissions. Most of them might not bother themselves in commercial cases to explain the case to the judges. They might just submit the bundle with all the documents, and they will walk out of the room. So those kind of benefits is very good. But more than this, Qatar have done a fantastic job by engaging local judges to work with those international judges to make which called the knowledge transfer. And then those local judges will go back to the commercial local courts and to spread that spirit. We have many things to speak about the international commercial courts and the benefit for the state. But I am here today to speak or to shed the light about the international commercial courts vis-a-vis the international arbitration. Why the international investors will take or will choose the commercial courts, not the international arbitration, or they might choose the international arbitration, not the international commercial courts. We have many reasons. If I put myself in an investor's shoes, I will make a comparison, or I will ask my lawyer to tell me why I should go for the international commercial court, but not the international the international arbitration. And the simple answer for this is the international court. You might find judges, and the judges have code of conduct. I am arbitrator myself, and I am working with fantastic arbitrators, but always the judges has another level to work with. And this is the one of the iconic feature of the international commercial courts. But on the other hand, we have some limitation about the enforcement, because enforcement will be through an international court, but within the system of the state. If you want to enforce it outside, you might have some difficulties if there is no reciprocal treatment with another state, especially the place where you want to enforce the judgment outside the inland. In arbitration, we all know that you can use the New York Convention 1958 to enforce the award in all signatory and ratified states outside the jurisdiction. This kind of tools is going to be studied extensively in front of the foreign investors before he chooses whether to go to the commercial courts or for the international arbitration. And each one has their features, which is make it very distinguished from the other one. I think this is what I have for the time being.
Thank you so much. And actually, you really gave me a good introduction to our next speaker, because it was good to hear how there is a difference between international arbitration and international commercial courts. And people are confused about that sometimes. When I talk here about the TICC, then the question I get, well, but we already have TIAC. Why do we need it? So TIAC, of course, is the Tashkent International Arbitration Center. So I'm very pleased we have here Diana Bezakova, who is the director of TIAC. Diana Bezakova received her law degree from the University of Westminster, and recently obtained a postgraduate diploma from the Said Business School at the University of Oxford. She practiced as a lawyer in Dubai until she returned to Uzbekistan to help with the establishment of TIAC, which has since grown to become a leading international arbitration center in Central Asia. So my question to you, Diana, is can you talk about the interplay between arbitration and the courts, and how does the TICC support TIAC, especially where the seat of arbitration is in Tashkent? And also, I'd like you to say something about the type of cases that TIAC is handling, in particular, as it will be an objective of the TICC to become a regional hub for the settlement of commercial disputes. So it will be really good to learn from TIAC's experience.
Thank you so much, Marianne, and the Ministry of Investments, Industry and Trade for having me, and for the opportunity to contribute to this important conversation about the evolving legal landscape that is to include the establishment of the Tashkent International Commercial Court, or the TICC. I also salute the leadership of the Ministry of Digital Technologies and the DTC for the implementation of this remarkable initiative. And my intervention today will focus solely on how the TICC may successfully support international arbitration, how it may support the work that TIAC is already doing in the field of international arbitration and dispute resolution, and also how the TICC will supplement the important role that the local Uzbek courts play in supporting foreign investment. And we've heard today from my distinguished speakers that the creation of the Tashkent International Commercial Court is actually about adding to the menu of options that investors would have, particularly for sophisticated international disputes with procedures and language that may be familiar to foreign investors. And when I talk about procedures and language, I mean procedures that are modeled around English common law principles and English as the language of the court proceedings. And going back to the question that you, Marianne, asked, and in order to address the need for such menu that I was referring to, we may look at successful examples of Qatar, of Dubai for inspiration. And when preparing for the session, I actually looked up the statistics of the DIFC court. It was established, as Dr. Nasser rightly mentioned, over 20 years ago in 2004. But they have really shown that a specialized English language court or English language forum grounded in common law principles may attract a vast caseload. To give you some figures, in 2024, the caseload of the DIFC court recorded over 1,000, or to be precise, 1,056 cases with an aggregate value of over $2 billion. But what's important in the context of this caseload and statistics is that the total value of claims related to arbitration at the DIFC court was around $1.8 billion, so very close to the total aggregate value of all claims that were administered by the DIFC court. So, and these are the cases where the DIFC court supported arbitration with interim measures. And when we talk about interim measures, we talk about, for example, freezing bank accounts or blocking property, etc. And where the DIFC court enforced arbitral awards issued by the arbitral institutions in Dubai and beyond. Importantly, again, the DIFC court in their official channels and official messages say that they're complementary to the UAE's Arabic language civil law system. So that is all to say that the Tashkent International Commercial Court may help with strengthening investor confidence, as investors oftentimes look for the legal environment that offers choice, the menu of options that I was referring to. So the availability of arbitration, economic courts, and now a specialized international commercial court means that Uzbekistan is offering a full spectrum of tools and instruments, each with its own role and advantages. You've asked me about TIAC, just very few words about Tashkent International Arbitration Center. 2025 saw a threefold increase in cases as opposed to the last year. We have administered in 2024 43 cases with international element. But what's important again, that a quarter of all cases, 25% of all the caseload administered by TIAC, involve both claimants as well as respondents as non-Uzbek parties on both sides. So non-residents in Uzbekistan were involved on both claimants and respondents' side. And to give you a non-confidential example, we have recently administered a case where Korean company Tech Cross Water and Energy, that's not confidential information. We have specifically requested written consent from that specific company to mention this. So Tech Cross Water and Energy had a dispute with the non-Uzbek party on the other side. Another successful example where TIAC assisted with dispute resolution is the case involving American Crossover Healthcare Fund, LLC. And we're aware that both companies have successfully resolved their dispute with the help of TIAC. So again, what we're talking about is that the TIAC will bring a forum that will assist in arbitration matters, for instance, applications for interim relief or recognition and enforcement of arbitral awards in the English language. I think this is the conclusion of my intervention, but I'll be more than happy to address any questions. Thank you.
Thank you, Diana. And I think it's really great to hear how successful TIAC has been and the international recognition it has. And it can also help the TICC, once it's established, to really get that same recognition, I'm hoping. So let's move on. I just want to now pass on to Professor Ruslanbekov. He is a doctor of law and currently the acting rector of Tashkent Law University. He's also an experienced arbitrator and listed as an arbitrator in more than 10 international arbitration institutions, including the only Uzbek listed as an ICSID arbitrator. He previously served as the head of department at the Ministry of Justice and represented Uzbekistan in arbitration, litigation, and asset recovery cases. He's also the author of many articles, textbooks, monographs on international dispute resolution, arbitration, and mediation. So pleased to have you. And my question is really twofold. First, how will the TICC transform legal education in Uzbekistan? I mean, this is kind of what you're doing with your, how does this impact on your law students? And what specific curricular changes are you implementing to prepare future lawyers in this court? And maybe secondly also, just keep it within the 5 minutes, what impact will the TICC have on the local legal community, particularly given, as we said, that foreign lawyers can appear before the court? So thank you. Over to you.
Thank you indeed, and for this question and for giving me the floor with such a kind introduction. And maybe I will begin from the second question, because at time it was already mentioned a little bit, we have some issues with the local courts. Maybe the economic local courts are overloaded with the cases. They have the cases and they review the cases only in Uzbek and Russian language. And if we analyze the cases with the applicable law, where the foreign law is applicable law, our courts are not experienced to review such a cases, and each time they try to change it to Uzbek law and implement Uzbek law as applicable law. And that brings an issue sometimes for the cases. And the TICC, if it will be established, it will give the possibility for the lawyers to present their cases in English language and to be reviewed based on a foreign law, with the applicable law as a foreign law. And also, the foreign lawyers, they can't appear in front of the Uzbek courts, because this is the requirement of Uzbek legislation. They can't be an advocate, and only Uzbek citizens can be an advocate, can get a license of the lawyer to present their clients behind the court. And the TICC will provide such a floor for a new practice which will bring to Uzbekistan international standards and the foreign experience. We can say that the TICC can become a legal laboratory for innovation of Uzbek judicial system. And appearance of foreign lawyers in this court and foreign judges and also an international experience will also bring requirements to prepare a new generation of lawyers who can be presented at this court, who can act based on the international standards, who can work fluently in English language, using a common law system and practice. And this is a big opportunity for now to change also the legal educational system. We are already working on that, and we are working with the UK and US universities for establishing a joint programs. We already established English law department at our university, and we agreed with the University of London that from the next academic year we will provide their degree programs at our university. That means that we need to already be prepared that there will be a big demand for the new lawyers who have the background of the common law system or the education of the common law system, not only the civil law system. So we think that the TICC would have its influence for the Uzbek legal system to change it also based on the international standards, to develop a new generation of lawyers who can work in these international standards, and that will give also the opportunity for Uzbek lawyers to become an international lawyers, like to work internationally based on the experience of the TICC. And we think that if there will be the TICC in the future, there will be good cases of TICC that will also bring a possibility to include the practice of TICC to legal education, to analyze their cases, to organize the moot court competitions for the students based on the TICC experience, and make it more popular around the lawyers and also the businesses. So in my opinion, the establishing of such a court will have a good influence to the legal community, to legal practice of Uzbekistan, and also to the legal education. So thank you.
Thank you very much. And it's really great to hear, because that was always sort of the intention also of the TICC as part of the reforms. This court is not going to be a bubble existing, in and of itself. The idea is to be a model for the judiciary, is there for there to be good cooperation with the judiciary of the country. So it's good to hear. And I like the word of the legal laboratory of innovation. I'm going to keep that one in. So as we said, this court is to support the investment climate and to support investors. So I'm very pleased we have an investor on our panel. I thought we shouldn't just have lawyers talking to each other. So John Zaidi, he's a country manager of Aqua Power, which is the largest foreign investor in Uzbekistan's energy sector. He received his PhD in management from the University of Auckland and has really had a very stellar career in the development of energy and utility sector projects, including in Kenya, Nigeria, and Uzbekistan, where he's currently managing an investment pipeline of about $15 billion in green energy projects. So, John, very happy to have you here on our panel. And I really wanted to hear from you. Do you agree with that statement that I made at the beginning, that investors do not only need a legal framework, but also a judiciary or protection, to enforce these rights that they're given under the framework? So how do you think this court can help this investment climate?
Well, thank you very much for the opportunity. Thank you for the Tashkent Invest Forum. We are a strategic partner for this for a few years now, and I think this is because Aqua Power with Uzbekistan is the second largest investment destination for us outside Saudi Arabia. So we really care about what's happening in terms of the reforms, in terms of how things are moving forward with such kind of portfolio. So it's very, very important for us to be on this panel. I am the odd one because I'm not the lawyer, but I do have the DNA of my two grandfathers who were both both sides were lawyers. So I hope I will not. I hope I'll live up to their expectations. But one thing for sure, let me start away, because investors love countries where law is not just a perception, but it's a reality. And it's good for business, and it's good for business, but it also means that we will have to use less lawyers, so which is a good benefit for us. We look forward to that. In terms of, before even going into the discussion around the court, I think the most important part is the trust. And there is a huge amount of research done across that the trust level within the society, the higher is the trust, the business is good. And I think there is a huge amount of influence which is now being in Uzbekistan, and the interest which you see over the last three years of this investment forum. And I've been in couple, and I see the interest which has grown, and the number of investors who are coming into this country shows that the trust level is huge. That means that it's not just between the overall business environment also, but the fundamentals where the law is not perceived as that it's biased, or it has its own negativity around that. When you're conscious as an investor coming into a new country, whether it will work, whether it will be enforced. So I think this perception already is low, and I think we, with addition, I believe that this new instrument, in a sense, will give more confidence, but it will be a complementary. In that sense, and I view as I think many of the investors, that it is an extension to what we already have it, and hopefully this will help allow us to build a understanding where disputes, which are inevitable, they will happen. Whenever you have a contract, commercial contract, things will go, over a period of time. It may not happen now, maybe in 10 years from now, but you all look forward to the fact that if ever it happens, there's an institution which will listen, which will value, and will bring something together that where the both parties agree to and can move forward to. I think nobody goes to court for the sake of it, but I think there is a trust level that yes, whatever the arguments we are going to place, whatever the view our lawyers or our partners' lawyers they think about, there is somebody who can sit down and give us a more justice, in a sense. And I think that fairness is the fundamental for any society, obviously, but for the system here in Uzbekistan, I think it's very, very key for investors to see that the system is fair. And it doesn't mean that it is only the investors have to win. I think we should be very cautious that how we approach the business. And in Aqua, for us, making an impact is a very important part of our strategy. We are here for a long term. We are here for 25 years and plus. We are the long-term PPAs with all its uncertainties around it. We believe in it. That yes, those uncertainties, if any disputes comes in, we hopefully will resolve it on a bilateral basis. But if not, there are places where we can go and discuss and debate and have a discourse around those disputes and trying to find something. So the additional instrument is definitely very much welcomed by the investors. I don't think anyone of investors will say not. But let me put also some cautions here. And the one big element which I do believe that and we talked about learning and bringing the new practices and bringing the new best practices from around the world, from Singapore to Dubai to other places where this is actually has shown its value. So it is very good. But I think the onus is also on the court to learn from the local judicial system also, to understand that there are certain amount of cultural dimensions. There are elements where the justice is viewed in a different way, and we need to educate ourselves. Just bringing the foreign lawyers is an excellent way to teach, yes, obviously, but I think the learning has to be on both sides, and there has to be an unlearning also, where we are able to challenge each other and the status quo which we have. And I think that is a caution which I think while we are going towards this new dimension and new instrument, that the learning has to be from both sides. It cannot be just assuming that because we know the language, because we know the English law, and therefore whatever we are going to bring to the table is the right thing. And I think that will be something we should be very, very off. The other part which I believe as investors, and especially from Aqua's perspective, the transitions which are happening in an emerging market, things evolve. And I think these kind of instruments can obviously bring new perspectives where the legislative bodies also can learn, they can bring some new reforms, they can understand how the stability and providing that stability of the country. It's not just the creating the environment. I think that's an easy part. Creating an environment where investors are comfortable is easy. It's the making sure that it will stay on the same level of trust, same level of comfort. I think that's where the challenge comes in, and that's where the President's vision of 2030, I think that's a great roadmap, and the whole support which comes from the Ministry of Justice also, and we would deal with that with them on a daily basis on many different aspects. But the way they approach and opening up these complementary options for us is definitely comforting, but with a caution that we need to understand the local dynamics, we need to understand the culture also. And the last thing probably will be from the investors' perspective. I think it's also important to see the fairness, to define the fairness when we are setting up the contracts, when we are trying to come up and invest and use this opportunity. We are very humbled. We are really very humbled to have this opportunity in Uzbekistan. You can't find parallels in Central Asia and beyond even, where the amount of green energy transition happening in a speed which is remarkable. And majority of the countries can't beat it, because getting a permit in other countries is like 3-4 years. And here we developed the project, it's already producing energy, and we are so much proud that more is to come. And it's not just Aqua Power. I think the majority of industry in energy sector, which is leading the transition and investment climate here, definitely will say that this is also a very important part. And the reality is that there's a lot more is discussed and resolved before even it becomes a dispute. And I think that spirit, coupled with this option that if you end up and having this kind of court, will definitely help us going forward, and that the trust level will continue going forward. So from Aqua's perspective, we welcome these reforms, and we are very happy to be in having that discussion also, that how it will affect investors, but also how investors can also make an impact on the system, which is very, very important for the energy transition. So thank you.
Thank you very much. Thank you. Very, very, very insightful, and to hear your views. And I like your word of caution that this court has to learn from the local system. It's actually interesting. A few points to mention on this. So, in the course of this project, a few years ago, with the support actually of the Asian Development Bank, we did a futures and foresight session, where we had the project team, including members from the judiciary, sort of discuss what this court means sort of for the future. And we looked at, I think we picked 2050. What would this court look like in 2050? And the view is that they would all be integrated. It wouldn't be like, a foreign versus national. There would be an integrated court. So I think the idea is, again, I said this, not to create this bubble. DIFC is a good example also, where initially the judges of the DIFC courts were all foreign judges, but I think now, 4 or 5 of them are Emirati judges sitting on the roster. And another example is in how in Kazakhstan, between the International Financial Center Court and the local courts, there's a lot of transfer of cases both ways. So I think that cooperation and sort of integration is very, very critical. So I'll come to our last speaker, last but not least. I'm really, really pleased to have on our panel Mr. Jamshid Urunov. He's the Deputy Commissioner under the President of the Republic of Uzbekistan for the protection of rights and legitimate interests of business interests, I think more simply known as the Business Ombudsman. Mr. Urunov has a law degree from Tashkent University of Law and completed his study at the Academy of Public Administration. He started his career as a prosecutor and was appointed to this position by the President in 2018. This is when the Business Ombudsman was created. So the Business Ombudsman has a different function as a TICC, but equally it supports the business environment and the business climate. So Mr. Urunov, my question is, in your role as the Ombudsman, you support entrepreneurs to protect their rights and specifically to help resolve issues. Can you tell me a little bit about the mechanisms, the tools that you have as the business ombudsman in providing out-of-court dispute resolution, and how effective you are in helping entrepreneurs resolve their issues. I think you will speak in Uzbek probably.
Yes.
Yes. So we have
With the
our
permission, of course.
we have our. Thank you very much.
Shu yo'nalishda olib borilayotgan masalalarni yoritishni o'zi bizga hamma tan olgan, uni ko'rib turibmiz. Yillar davomida o'sha davlat rahbarining tashabbuslari bilan tadbirkorlarga sharoit yaratish bilan bir vaqtning o'zida ularni himoya qilishga ham katta e'tibor berilyapti. Shu natijasida 2017-yilda O'zbekiston tarixida birinchi bor Biznes ombudsman instituti tashkil qilingan va biznes ombudsmaning faoliyatini tartibga soluvchi turli xil qonunlar qabul qilingan. Shu jumladan biznes ombudsman to'g'risidagi 2017-yilning o'zida maxsus qonun bor. Bundan tashqari investitsiya faoliyati to'g'risidagi qonun bilan ham biznes ombudsman eslatib o'tilgan. Biznes ombudsman qanaqa qilib tadbirkorlarning huquqlarini himoya qiladi degan masalaga keladigan bo'lsak, raqamlarga birinchi bir e'tibor berish. O'tgan 8 yil davomida 2017-yil tashkil qilingan bo'lsa, biznes ombudsman 50 mingdan ortiq murojaat kelib tushgan tadbirkorlardan va shulardan 40 mingdan oshig'i tadbirkorlar manfaatida hal qilingan. Bundan tashqari tadbirkorlar huquqlarini buzgan yoki o'z vaqtida ularga yordam ko'rsatmagan mansabdor shaxslarning 14 mingga nisbatan
prava.
Shu bilan birga biznes ombudsman yordami bilan 12 ming gektardan ortiq yer maydonlari tadbirkorlarga qaytarilishi ta'minlangan. Endi qanaqa qilib bu ishlarni biznes ombudsman amalga oshiradi deydigan.
Sorry, there were some technical issues. Now everything is resolved. So business ombudsman has accumulated some experience in protecting the entrepreneurship. And a lot of attention is paying to digitizing, and there is a virtual office that has been created where the entrepreneurs can address either through the call center in a written form or directly to the business ombudsman and sign up for an appointment. And business ombudsman controls the decisions and by processing big data. And also there is analytical tools that are applied, and systemic issues that could arise for entrepreneurs. This system monitors all the decisions and inspections that take place, and business ombudsman overviews how these inspections are carried out and whether they're effective. And this platform allows to analyze the activity of this enterprise, and we deepen the digitizing, and a lot of steps are being taken every day in this regard. And we're also starting to apply AI tools, and when we also when we receive different complaints or the requests to provide protection, and there are different directions in which we work. Firstly, we review the complaint or the request or the claim, and then based on that inquiry, we do a study and of that specific enterprise. And usually there are frequently asked questions based on which we can make a judgment that that entrepreneurs may be facing the same problem, and that's how we identify the systemic issues. And we try to scale our work not only in the regions but also in the districts, and we organize different days for meetings with business ombudsmen. And when we see some alarming issues, we try to correct and regulate those issues. So Business Ombudsman is the institute that addresses the systemic problems and challenges. And we try to learn from the best practices of business ombudsmen abroad, because we also have the right to regulate the issues and find solutions and systemic studies. And also we can make amendments to legislation based on these studies and research. So I wish you all great work, and thank you for giving me the floor.
And disputes resolution, but as we know, it's always better to resolve disputes out of court, and we need the mechanisms to do that as well, like mediation. And so the business ombudsman's role is very important here, as well as sort of helping, really by seeing the issues, help to improve the business climate, improve laws as they need to be changed. So thank you very much for that. So I think we're almost at our time, but I'd really like to open the floor to maybe one or two questions from the audience. Is anyone who would like to ask a question? I think we have, I'm not sure if we have a microphone. I think we do have a microphone. Any question? There's a question, yes.
Dear guest, let me represent myself. I'm Murat Bek. I'm a representative of the Ascopompe Italian company. We opened a company 3 years ago in Uzbekistan. All of our, let's say, shareholders are Italians, let's say 100% European company. And my question is to Mr. Jamshid Urunov. Mr. Jamshid Urunov, so we know you very well as a businessman, as entrepreneurs, but last month, on the 20th of May, we wrote a message to you because we have a pre-court, some dispute with some local company. It's a government company, and we have not received any comments. So maybe it was from email. I just want to send a message that it was written by mail, and normally in Uzbekistan, the messages written by mail is a little bit ignored. So maybe because I know this fact from the other companies also, because this dispute was also written to another government companies. None of them, maybe they ignore it, or maybe they didn't write it. So it was just for you a question. Maybe we have to write it personally by hand or something like this.
Thank you very much for this question. I think what I like to propose is that you speak to each other when we're finished in 2 minutes and resolve this issue. Thank you. Thank you very much. Any questions from the audience? Any questions? No questions at all? No? I think we actually have come to the end of our hour. So actually, I'd like to ask one question. Mr. Urunov asked me if I have time to ask him one more question. Does he support the establishment of the TICC?
Albatta. Sababi
Of course. I used to work for prosecution system in the past, and as I was part of the law enforcement, and the competition is always good, I believe. And of course, the entrepreneur needs to have the right of choice, and also they have to be able to choose where to go in case of a dispute. And I think that this could serve as a very great ground for fairness, where they can seek transparent decisions, and also that would lead to the more responsible competition in our society. And also, if this court is established, then there should be a structure that should oversee the application of these laws, of these decisions that will be made by the Tashkent Commercial Court, and that will make it whole. Thank you.
Thank you very much. My very last question to Dorpla Gemelin, please. You like to?
Well, you see, I really liked what my neighbor, the ombudsman, said. But let me, let's say, simply underline out of my experience what the colleague from Qatar said. I think a system that is independent from government is more confidence building, and it is on the long run better. But as a lawyer, I would always recommend 4 steps. Because you see, first step only could be to negotiate between the partners or the disputing partners themselves. Second step could be, if they don't, let's say, achieve to come to a good and satisfactory result, to ask a mediator, then an arbitrator for the third step. And then I think the last step in this row could be a court, because of course everyone, let's say, wants to avoid to be a winner or a loser. They all are looking for a win-win settlement. And I think if you have the options all on your side, then it would be best. So I'd really recommend the Tashkent International Commercial Court, but don't neglect the other steps before. Thank you.
Absolutely true. So thank you very much. Thank you to all the speakers. Fantastic to have you here. Thanks for making the effort. Thanks for coming all the way from Germany, from Qatar. And thank you to the audience for listening to us. Thank you.